Good afternoon. Welcome to today's webinar on climate change lawsuits and preemption and displacement of state law, an analysis of the Sunoco Cert petition currently pending before the U.S. Supreme Court and for which respondent's brief was filed less than 48 hours ago. The webinar is sponsored by the Law and Economics Center at George Mason University's Antonin Scalia Law School. And I'm Donald Koshin. I am a professor of law here at the Scalia Law School, as well as the executive director of the Law and Economics Center. And I'm pleased to be moderating this discussion. This webinar is designed around the mission of the Law and Economics Center to serve as a nexus for academic research and education that focuses on the timely and relevant analysis of legal and public policy issues facing policymakers and judges nationwide. Our commitment is to developing original, high-quality law and economics research and educational programs like the one today to further enhance an understanding of economics and to provide information that is useful to the legal and public policy debates surrounding these issues. We thank you all for being part of this ongoing dialogue. Our panel today includes three leading experts on climate litigation, torts, and the court system. So that we can reserve time for substantive discussion, I will give only a brief introduction rather than extensive bios. But I do encourage you to go to the email that you received as a result of being registered for this webinar, or to masonlec.org and the page where you clicked on to watch this webinar, or on YouTube, in order to get more extensive bios and to see the extensive experience of each of our panelists. Our distinguished panels today includes Phil Goldberg, who's managing partner at Shook, Hardy & Bacon, LLP. He also filed a brief in support of the petitioners in this case for the National Association of Manufacturers. Catherine M. Sharkey is the Siegel Family Professor of Regulatory Law and Policy at New York University School of Law. And John Yu is the Emmanuel S. Heller Professor of Law and Faculty Director of the Public Law and Policy Program at the University of California at Berkeley School of Law. He also filed a brief on behalf of himself and Professor Richard Epstein in this petition. The panelists will offer opening perspectives, talk a bit with each other, and then we'll open it up for audience Q&A. If you have questions, please use the the Q&A button at the bottom of your screen. Identify yourself in the text and also keep your questions short so they can be fit to and incorporated into this virtual format. So with that, let's get started. Phil Goldberg, tell us a little bit about what's happening in these cases.
Well, thank you, Donald, and thank you to Professor Sharkey and you for joining us today. It's good to be with you, and to Angelica, who's behind the scenes pushing all the right buttons. So thank you for that. As Donald said, my name is Phil Goldberg. I am special counsel to the Manufacturers Accountability Project, which the NAM started several years ago because manufacturers have been concerned about this new trend in litigation. And essentially where manufacturers are being sued over what are really social, political, sometimes even criminal issues that are related to the use or misuse of products. Often the products, like here, have risks that are well known. Governments have and continue to encourage these products, and people often need and rely on them for their everyday lives. Here, for basic things like driving our cars, heating, cooling homes, electricity, running factories. And so from the concern from a legal perspective, which is obviously why we're here talking about, is that these litigations often kind of skip over core liability requirements, elements of causes of action, objective ideas of wrongdoing, proximate causation of any alleged wrongdoing to the harms that they're being asked to pay for. And climate litigation is just one, but one of the more important and more expansive of those theories. I think where I'd like to start, and I often try to start this way in these kind of conversations, is to kind of figure out where we agree and where we disagree. I think where we all agree is that climate change is a serious problem. It is something that needs to be addressed globally and locally. And it's a byproduct of 150 years of the way we have been living on this planet. Electrification was widely seen as one of the most important quality of life and standard of living events of the last century, from refrigeration, again, heating and cooling homes, transportation, healthcare, and how we achieved those advancements over this past century or so is not how we're going to continue to operate and achieve those advancements and go further over the next decade, 2 decades, next 150 years. So the challenge that we have from a climate perspective is to figure out how we can live in this modern world without impacting the climate and without harming the planet. And the way to do that is to source and use energy in ways that are more sustainable, among many other things. So where I think we disagree, and we'll obviously get into some more of this over the next hour and a half, is what the solutions are to this problem and what the propriety of this litigation is in that equation. So to be clear, this litigation will not solve climate change. The cases themselves, all the complaints say that they expressly disclaim any impact on the production, sale, or use of any of these energy sources. The claims have no legal foundation, from public nuisance to consumer protection. Selling us the energy that we need to live in modern life is not a liability-inducing event. It is premised on a desire for some communities to have money for local infrastructure projects. That's not a liability theory. Just earlier this week, the National Taxpayers Union came out with a report showing that there are $40 billion that are available for local mitigation projects under recent federal infrastructure bills, and only about $9 billion have been allocated, and about $224 million have been spent. So there's a lot of money for local communities that they can get access to, and they can do it more quickly than dealing with litigation. And so if the goal is about funding these local projects, that money has been made available in decent quantities. And then ultimately, if we're saying what's the end game for and how we're going to deal with climate change, this is a distraction from the things that actually have to happen. So the innovation and all of that. I'd like to spend a few minutes kind of putting this into this current wave of the litigation into its historical context, because as someone much more famous or smarter than I am once said, that anything not put in context is pretext. So about 20 years ago is when climate litigation started in earnest. The goal was to leverage the litigation system and liability to achieve political and policy goals, and that was the full acknowledgement of what the litigation was about. I remember 15 years ago being at a conference at Valparaiso Law School, which I think no longer exists, and the title of it was "Litigation's Role in the Path of U.S. Federal Climate Change Regulation." And so that's what the whole debate was. There were, and it was largely based on the frustration that not enough was being done in Washington and by regulators, and and all that. There were initially 4 climate lawsuits. Probably the one most people know is AP versus Connecticut, and it was kind of like a legal laboratory of litigation. Like what's going to work? So they tried. Some of the lawsuits were from government plaintiffs, some were from private individuals. Some were suing users of energy, like in AEP, the power plants. Others were pursuing the producers of energy, like the ones here. Legal claims were federal and state law, mostly public nuisance, like we're seeing at least in many of the cases here. And they sought different types of remedies, some injunctive relief, some abatement, some damages, and ultimately AEP versus Connecticut went up to the Supreme Court. And that one was packaged as state plaintiffs against the utilities under federal public nuisance law seeking injunctive relief. And the court unanimously ruled that deciding these issues is not the role of the courts. The legal ruling was that the federal common law had been displaced, and so therefore by the Clean Air Act, that Congress displaced the federal common law enacting the Clean Air Act. And so, but the ruling went far beyond that and talked about the roles of the judiciary, that climate change is a question of national and international policy. It's about balancing competing interests, affordability, energy independence, and other environmental concerns. And you can't regulate this through these ad hoc case by case litigations. And And they said that this was also not suitable for state law. Though state law was not part of the case, and so they didn't specifically rule out state law, and they acknowledged that in the ruling, but did say that it was not appropriate governance for state law. In the Ninth Circuit, Kivalina there's a Village of Kivalina case, very similar to the cases today. Local communities suing oil and gas producers for local harms over abatement of damages. And the Ninth Circuit said, we hear what the Supreme Court said, and it would be in Congress for us to revive this in another form. And Comer, which was a hurricane case in Mississippi, reached the same conclusion that was brought under state law. And so in 2012, the people behind a lot of this litigation got together and said they still think that litigation was their best hope for pursuing changes in national policy changes. But they said, oh, how do we rejigger this litigation so it doesn't look like AEP versus Connecticut? And so they said, well, let's ask for money damages. One person said, even if your ultimate goal might be to shut down a company, you still might be wise to start out by asking for compensation for injured parties. And don't take my word for this. This is all published online. It's actually, they issued their own report. And so taking it from the report that they said. But, they said that, so as the litigation has progressed over the past few years, there are people that are involved in this litigation that have explained exactly that this is what litigation ultimately is about. Some have talked about using the litigation to raise the price of energy, holding consumers responsible for climate change. I've been in these kind of debates with people eloquently talking about that the litigation is an effective way to put a penalty or a tax on carbon use. Last week, or I think it was, the Attorney General in California did a whole 45-minute to an hour-long presentation on this litigation and talked about that this was creating an extra cost onto these energy sources. And then the people talked about driving pressure on the courts and using, naming the campaign and trying to create outrage in people's mind because they try to diminish the credibility of the voices against the reforms that they were looking for. And so the goals of the litigation were to use it as a policy tool. They want to reduce energy use, increase the cost of using energy, package litigation as money for local communities, so they thought would be more attractive for local politicians, and then stay in state courts that they thought would be more sympathetic to this local argument, and then leverage the PR and all that around the litigation to demonize the industry in the minds of the public, and then apply pressure to them politically. None of these are valid liability theories, and a lot of times people, when in these conversations, will acknowledge that, but say in the fight against climate change, all's fair. And so we just not need to do everything. Right now, there's about 30 of these lawsuits that have been filed. They're packaged completely, kind of like the legal laboratory from 15 years ago. There's but the key issues I will say are do we apply state law or do we apply federal law? We're suing, what about suing energy producers versus the power plants in AEP? Are we seeking damages or abatement, injunction, whatever it might be? But that's where the pressure points tend to be right now, and how this is playing out. But at the end of the day, the litigation is largely the same. It's the same national policy goals, and it has the same legal deficiencies. So far, so this round of litigation started in about 2017, and so far the driving questions have been, whose ballpark are we playing in and whose laws apply, right? So is it federal or is it state? And the entire strategy, again, by the plaintiff side, is to leverage the parochial interests of local governments and plaintiffs and local courts as decision makers. So they want to be in state court applying state law. There are two completely different legal issues that this raises. One is removal to federal court and whether the case to get remanded back to state court. That dominated the legal dialogue for 3 years or so. Last year, the Supreme Court decided not to take a petition that would have decided that question. And then most of the circuits had said that these cases should be remanded to state court because of the well-pleaded complaint rule. They were pled as state cases. The question today is, does state law or federal law apply to the interstate international emissions and the underlying conduct that's at issue in this litigation? And that's what the Honolulu petition teased up to the Supreme Court, and what the Supreme Court will be determining whether it takes this case and decides this issue. Here, there's a direct split from below. The Second Circuit in New York City's climate case in 2021 said state law cannot govern emissions and other activities around the world. They said the suits seek to subject a handful of energy companies to state liability, quote, for the effects of emissions made around the globe over the past several hundred years. It said this type of, quote, sprawling case simply beyond the limits of state liability law, and echoed the Supreme Court in AP versus Connecticut that the litigation raises special federal interest. And they said artful pleading cannot transform the city's complaint into anything other than a suit over global greenhouse gas emissions. So what the Hawaii Supreme Court said in the Honolulu case is just the opposite. It said that, and the key question is whether these are acts that are being subject to Hawaii law took place actually in Hawaii, or do they take place in other states and other countries? Are the emissions at issue take place in Hawaii, other states, or other countries? And so as the Second Circuit said, under these theories, any local government could bring one of these lawsuits and pursue money damages from any number of companies or industries to pay the government past and future costs of climate proofing its infrastructure and property. These are not, the reason why these are inherently federal cases is because any state, any person, any entity could be sued, could bring a lawsuit. It's not tied to any local area. In fact, the California case in the recent venue ruling said, if ever there were litigations that could be described as truly global in scope, they are these. Regardless of which government entities have brought these lawsuits, the interests potentially affected by the issues in these cases apply equally well to populations in San Francisco County, Contra Costa County, and on. These are not lawsuits with a local focus or local stakes. And the Obama administration cautioned about this back in AP versus Connecticut. The Solicitor General said that there would be almost unimaginably broad categories of both potential plaintiffs and potential defendants. It would be impossible to consider the sort of focused and more geographically approximate effects that were characteristic of traditional nuisance suits. And in fact, one of the Delaware courts said, if you're suing in Delaware, these, in one of these climate cases, that the out-of-state or global emissions of interstate pollutions are beyond the limits of Delaware common law. And so the Hawaii ruling, which is what's being appealed, directly conflicts with the Second Circuit, with Delaware, with a lot of the legal thought that's been out there regarding whether you can subject Hawaii state law to the marketing, production, sale, all that of these energy sources outside of Hawaii, in other states where they might find that the conduct that occurred in their state to be completely legal, in other countries that might be considered to be completely legal. And so the reason why with these cases involving interstate emissions that you need federal law is because you need uniformity, you reduce parochialism, and it's a greater likelihood of adhering to the law. Just in the last minute or two that I have for my 15 minutes, I just want to say that there's a practical cost to this litigation. The idea of creating this penalty on carbon outside of the checks and balances of the legislature, which is ultimately, again, what this is about, doesn't allow the hearings and discussion on different competing interests, who's paying this, where the money's going, all that kind of stuff. These are factors that legislatures consider when doing this, as opposed to courts that are looking at two parties, rules of evidence. They can't make their decisions on sort of the broader policy issues, but they're being asked to make these policy decisions. Just as an example of that, in this litigation, there have been about 15 to 20 state AGs, depending on the case in the year, that have filed amicus briefs against us saying, whoa, like, we don't want those states deciding our state's policy on climate. We don't want those states to make our people have to pay more for energy use. We've got our own issues. We have our own climate issues we have to address. And so it's pitting these states against each other, which again is why these are federal issues or for federal law. This litigation can make climate change worse. And I know that sounds weird to say, but one of the concerns, and the New York Times kind of reported on this about a couple of years ago, is that when the companies that are being sued here reduce their production of these energy sources, that doesn't mean the world's going to have less fossil fuels. It means that the OPEC and other nations are going to increase their production. That's what the Saudi Aramco CEO said. Of course, we're trying to benefit from the lack of investment of major players in the market, and they predicted that OPEC would increase their share of the oil market from 55% today to 75% over the next 20 years as this kind of shift happens. These entities are not responsive to American policymaking. They're not focused on climate the way we are in this country. They don't have the same attention to the environmental concerns. And then as it kind of started, the concerns generally with the manufacturing community, and beyond just the energy producers, is that it seems like a free kick to say, oh, let's just go sue the people who made the product and who profited from it. But that's not the way the liability law works. And obviously this is a discussion of legal theories. And so, and there's a cost even just to pursuing that litigation. And that's, and I think where some of the challenges are. And so, I think it's understandable that we have disagreements. It's a very passionate issue. And deservedly so. There's a lot of ideological, geographical, technological questions that these raise, which is why they make for such fascinating webinars like this. But at the end of the day, I think frustration with policies should be focused on the policymaking branches of government, the legislature, and the federal agencies, and then the courts for focus on the liability issues that they're very good at handling.
Thank you, Phil. That's a great way to get us started. And let me just ask you one question before I turn it over to Professor Sharkey. Can you do just a 30-second summary of the holding in the Hawaii Supreme Court case that we're really that we're going to be focused on in the petition? And then my second question is, as the Supreme Court reviews this, is the theory or the ultimate holding in Hawaii, would it allow, if sustained, would it allow for every state to apply their common law to these activities?
Well, so I mean, the holding in Hawaii, and Professor Sharkey could probably expand on this as Professor Yu as well. It was to allow the state, or allow the city of Honolulu to sue under Hawaii state law for what it said are the damages that are to abate the damages that they say occurred in and are going to occur in Hawaii over over climate change, which is the result of energy use and other things, frankly, everywhere in the world. And so the practical implication of that is applying Hawaii law to conduct and emissions around the world. And so that's the kind of the nub of it. But I'm sure, if the others want to talk more about what Hawaii Supreme Court said, welcome that.
Great. And rejecting the idea that federal law would either preempt or displace the application of Hawaii law in that.
Right. That's exactly right.
And so consequently, if this were to stand, and every state would have available to them the application of their common law to the same defendants and the same activities. Is that correct?
Right. Yeah. And one of the issues, and I was kind of thinking we'd probably get into more of this in the Q&A, but I guess we're doing Q&A now, is this weird legal question of whether federal common law exists, and if it doesn't exist, what happens? And so in AB versus Connecticut, the court said these are issues of federal common law, the interstate emissions and all that. But the Clean Air Act has displaced the federal common law and empowered the federal agency, the EPA, to make decisions on emissions. And so what the question is, okay, so if we say, defendants are arguing that federal common law governs interstate emissions, and then what happens once you're in federal common law, what happens? Well, as AP versus Connecticut said, that's been displaced in this area by the Clean Air Act. So a lot of the courts, like Hawaii, are saying, well, if the federal common law has been displaced in this area, then how can we say these are matters of federal common law? But there's a two-step process. Is it a matter of federal common law, step one, and then step two, what happens as a result of that? What the Hawaii Supreme Court said is, well, because it's been displaced, because federal common law has been displaced, you don't get to it. It's not there to even go up to federal common law. And that's something the New York, the Second Circuit in New York called that theory too strange to be true. That the idea that something is an inherently federal issue and arrives under federal common law because of the interstate nature and global, the federalism nature of our government and all of that, it doesn't become a matter of state law simply because Congress acted on that federal interest and then assigned it to a federal agency. And so that friction between the Second Circuit and the Hawaii ruling, I think is going to be fascinating, and frankly something I think the Supreme Court should find an incredibly interesting legal issue to decide, because that is something of importance. And so if any time something should have been something of federal interest, under our system of governance, and should have been under federal law, well, if Congress acts on it, all of a sudden now it becomes an issue of state law. It just doesn't make sense. And so that's we'll see how that plays out, but I think that's something that the Supreme Court would want to speak to.
Excellent. Thank you very much. A couple quick reminders. One is that those of you familiar with LEC webinars know that we often go for an hour. We are reserving an hour and a half today, so this will be a 90-minute program. So please stick around, stick with us for the full 90 minutes. And then second, I wanted to remind you that the Q&A button is at the bottom of your screen. Please go ahead and post your questions there. We will then go through those questions after the opening remarks with all of our panelists. So with that, I turn it over to Professor Sharkey.
Great, thank you. And thanks for including me on the panel. I think actually where we just ended is a perfect jumping off point, because while I'd be prepared to discuss, we can do it in the Q&A, we could do it on a different webinar, questions such as what are the best solutions to global climate change, what is the intricate role between tort litigation and federal administrative regulation. I teach tort law, I teach administrative law. I'm fascinated by such questions. I think here that the legal issue that the court's going to have to think about is exactly where Phil and you just landed. Namely, if you think back in 2011, in the AEP versus Connecticut, which was a unanimous United States Supreme Court decision, the court did decide in that case that a federal common law claim of public nuisance was displaced. This was a federal common law claim against the nation's largest emitters of CO2, and the court did hold that this was displaced by the Clean Air Act. They explicitly left open, as Phil mentioned, the question, which is a separate legal question. Displacement is about federal interaction. So the idea there is federal common law, which is supposed to be a very narrow enclave of kind of judicial policymaking that operates in the interstices where Congress hasn't spoken to an issue, would be displaced as soon as Congress speaks to the issue. That's what happens with federal displacement. The court recognized, and there are a whole host of areas, I know, Phil, you're intimately familiar with federal preemption in lots of areas having to do with products, medical devices, drugs, et cetera. So the federal preemption question, which they left open, was the extent to which the Clean Air Act would preempt or oust state common law actions. So it's a different legal question. And I think I'd like to start by saying this is a question that was left open, and I would argue not tackled head on, although one might disagree with that and say it was tackled by the Second Circuit in City of New York versus Chevron. The reason I think it wasn't tackled head on is if you read that case, actually the first time that I read the court's opinion, the lower court's opinion, the district court's opinion, I thought that the litigants had filed federal common law claims. It was written as if they had. And then I went back to the complaint and saw that the City of New York had filed state tort law actions in trespass and nuisance, like the case that we're talking about in Hawaii, in Honolulu. And so what the Second Circuit reasoned is that the city's state law tort claims in public nuisance and trespass necessarily arose as federal common law claims. It's not entirely clear to me what the legal basis for that. It's quite extraordinary, actually. If we take some of the policy arguments that Phil was mentioning about issues that have, interstate externalities, issues that are quote unquote too big for state tort law, right? The implications of that, including the need for national uniformity, they would suggest, for example, that a whole host of issues, let's take state failure to warn of products that are sold in interstate commerce, et cetera. Those two, one could argue, should be governed by federal common law, not by state tort lawsuits. So, and once the Second Circuit decided that such claims arose only as a matter of federal common law, they then concluded, as I think all legal watchers, commentators would say with solid doctrinal analysis, that federal common law is displaced by the Clean Air Act, right? But what the key question that I think was still left open until the Honolulu case is the separate federal preemption claim. So if federal preemption is distinct from displacement, that's the first point that I want to get out there today for discussion. I think it'd be difficult to argue that those aren't analytically distinct, different legal doctrines. So, for example, with federal displacement, it's quite clear that the standards are quite low. Namely, Congress just has to have spoken to the issue. No one has to have done anything effective. No one has to have regulated stringently or not in an area. Just Congress has to have spoken to the issue. And in fact, it's almost as if there's like a presumption in favor of displacement of federal common law. Federal common law is disfavored because it's just a matter of judicial policymaking, whereas the policymaker should be Congress. Federal preemption of state law, of course, is distinct. There's a lot of disagreement in the US Supreme Court about federal preemption of state tort law in a lot of different areas. So unlike the AEP versus Connecticut case on federal displacement, which was a unanimous decision, typically with federal preemption of state tort law, you get fractured decisions. Some argue, most people will say, and the Supreme Court always touts, whether in majority or dissent, that federal preemption of state tort law invokes the supremacy clause, namely that in our federalist system, federal law is supreme over state law when there's conflict. And they also will say that the touchstone is legislative intent. So what's interesting in federal preemption of state tort law, historically, the idea was that there was a strong presumption against preemption of issues that were historically the purview of the states. The US Supreme Court in recent years has not been putting as much weight on that presumption against preemption, but they have put a lot of weight on looking at the statutory framework, the specific statutory framework. And in this case, that would be the specific statutory framework of the Clean Air Act, looking at that particular statute and asking the extent to which that preempts state tort law claims. Now, just as a footnote and something we might come back to, what's really fascinating about this case is that the petitioners read the underlying case to say it's about tort law claims relating to emissions. So these are climate emissions claims that you can artfully plead them however you wish, but that's what they are. The respondents claim that the Hawaii court below argued that these were not emissions claims, these are claims for deceptive consumer marketing and failure to warn, et cetera. So what I want to argue is, regardless of the alternative framing, regardless of whether these are claims relating to emissions or whether these would be claims of failure to warn or deception, that the case for preemption under the Clean Air Act is very weak. The Clean Air Act was passed against a history of very active state involvement in both common law nuisance claims and then increasingly state regulatory efforts. Most experts on federal environmental law describe it as a, quote, cooperative federalism model. And federal preemption of state environmental law is truly the exception under that statutory framework. You could look at particular statutory features. There are very broad, what are called savings clauses in the federal statute, such that the idea is that they are imposing federal standards that will operate as a floor, but not a ceiling. There's a lot of acknowledgement that states will be free to regulate on top. So I think that I think what gets a little bit lost, in this discussion is what would energize the U.S. Supreme Court to get involved in this issue. I do believe that the U.S. Supreme Court should resolve at some point the issue that was left open by AEP versus Connecticut, namely not the displacement question, but the issue of whether the Clean Air Act preempts underlying state common law nuisance actions. I'm not sure now's the time. As I said, I don't believe, to my mind, the Second Circuit's decision gets at this in a kind of inadvertent way by deciding that such claims could be only a matter of federal common law. The U.S. Supreme Court, by denying cert in all of the cases in which the removal issue was presented to it, and which is slightly different, but allowed at least the courts to say, does federal common law, is this complete preemption? Namely, is it the case that you cannot conceivably bring public nuisance claims in this area? And unanimously, those cases remanded back to state courts on the theory that there was not complete preemption, and the U.S. Supreme Court didn't show any appetite to intervene by granting cert there. I think this is a court that is cautious with regard to federal preemption issues, has put a lot of attention on the particular statutory framework in which these claims arise. I think that a lot of the really interesting issues that Phil raises to the table are fascinating issues that I think state courts and federal courts that are in diversity hearing state claims will have to wrestle with, namely, first and foremost, what is a public nuisance claim? Should this be very limited to land-based kinds of effects? What does it mean? The second restatement calls public nuisance, right, a significant or an unreasonable interference with a public right. What are the metes and bounds of that? We actually today see state courts coming to differing conclusions in areas like opioids and the like about the metes and bounds of that as a tort claim. I know Professor Yu and my colleague, Professor Richard Epstein, wrote an amicus brief in this case where they talk about the issue of if the underlying cause of action is really one of fraud or misrepresentation, that it seems not to fit the elements of that. This was a case that was pled as public nuisance and trespass, but I think they're very interesting issues about, how the common law should address these kinds of causes of action. And I also agree with Phil that they raise enormously interesting causation questions, allocation of responsibility, damages mitigation, maybe comparative negligence, et cetera. But those aren't the kinds of things that are going to get the U.S. Supreme Court involved. So I think, as I said, that there is a very interesting legal open issue about preemption of state claims. My best prediction would be that the US Supreme Court would allow that issue to percolate. My understanding is it is pending in some other cases. They might want to see that framework as laid out below before deciding whether to intervene and address that question. So I think I will end there and reserve my time to have some extra time after Professor Yu. I might say each of them has filed amicus briefs in this case on the side of the petitioners. I'm not filing any briefs in this case. The respondent did just file their brief, I think, on May 1st. So there may be other amici who are weighing in on that side.
Thank you so much, Professor Sharkey. And a reminder, you can use the Q&A box at the bottom of the screen, and we'll get to those in just a bit. I'll turn it over to Professor Yu to continue the conversation.
Thank you, and thank you to the George Mason Center here for putting this panel together. It's wonderful to be united with these, the moderator and the speakers. Donald, I knew, was an untenured professor at Chapman University, and he strangely made the decision to move from Orange County to Arlington, Virginia. Your sanity must be questioned. Catherine, I'm really glad that I think Catherine and I agree. This is great because she and I have both had the fortune, maybe trial by fire, of co-authoring things with Richard Epstein. And so we might both cite Richard on opposite sides of the issue here, which I'm sure happens all the time to him. It makes him very happy. And Phil, all I can say is your firm has the greatest name in the history of legal practice. When I hear Shook, Hardy, and Bacon, it actually makes me very hungry for some kind of breakfast sandwich. So it's great to be with all of you, and I find myself agreeing with much of what is said. Let me just sort of overlay it with a federal court's perspective, perhaps, or a constitutional federalism perspective that I think may urge in favor of the court granting cert. In comparison with Catherine, I think we both agree this is a cert-worthy question here at bottom, and the question is it better for the court to grant cert now or to wait a while? I think that, as she said, AEP, and as Phil said, AEP leaves this question open. The question of, do state tort lawsuits survive the ousting of federal common law rules on global warming, or actually just interstate aerial pollution in the wake of the Clean Air Act? This is a very interesting and difficult question. The court did not, it just left it in AEP, and we're now seeing the result of that decision not to address the question fully, and you're seeing hundreds of lawsuits. It's not just states that are going to bring suits, it's cities and counties, which there are many in the country who are bringing these kinds of lawsuits. I think there are other aspects, and I think what I will end up focusing most of my comments on is if the court were to take cert, and I think this is really interesting from a law and economics perspective, which is the focus of the center. When do you want to have a single national solution versus decentralized competitive federalism? Do you want to have a single federal common law rule or statutory rule? When do you want to allow states to regulate things? This also intersects, I think, with the Roberts Courts project, which is a continuation, I think, what's been going on with the Rehnquist Court, which is to reinvigorate federalism based on some kind of original understanding analysis. How would the court think about this question, given that it has paid a lot more attention lately to the balance between states and the federal government that the founders might have intended? I think that's going to be, one of the crucial questions for the justices. So I think, I don't disagree in terms of the cert worthiness of the question. I tend to see more of a circuit split, perhaps. I did look at the response by Honolulu, which just filed a few days ago, and they claim there's no split at all. I'm not so sure about that. In fact, the Hawaii Supreme Court seemed to think there was a split in the federal circuit courts. They, one opinion we didn't really talk about much is the Fourth Circuit's case, and a case brought by Baltimore. And Baltimore and the Second Circuit seemed to reach different outcomes on whether states could use their state tort law to sue against fossil fuel companies for global warming when pled out in this way. And the Hawaii Supreme Court openly says in its own opinion, we see these two different trends, two different lines of opinion. They do say the Second Circuit is all by itself. I think that's true. Most of the other circuits have followed the Fourth Circuit, it looks like. And Hawaii Supreme Court just says, we pick the Fourth Circuit. We're going to go along with the majority view in the Circuit Courts of Appeals. I could see why Honolulu would want to downplay whether that conflict exists, but I think it's hard to say that there's no conflict. I think this is a issue, perhaps as Professor Sharkey says, you could have more percolation perhaps, and you could get maybe more opinions out there. I'm not sure what the percolation would add. I think that's the case that would confront the Supreme Court initially in granting cert, given they have a cert-worthy question before them, is further discussion in many of these other cases that are coming forward make a difference. I'm not so sure, and I would defer to Phil about this because I have not looked at a lot of the other cases that are bubbling up there but haven't made it up to the appeals courts yet. But they seem all the same to me. I mean, they seem kind of cookie cutter. In fact, it seems to be the same law firm is bringing a lot of them. So that might cause the Supreme Court to look at this and say, I don't think there's going to be, more information produced, right? That's the idea of percolation, whether it be more information produced for the courts from these other cases, given that they're very similar, almost identical in many aspects. If that's the case, and they do grant, and I think they have some reason to, because of other kinds of issues that they may pay attention to. This is sort of things I'm much more interested in. I'm not an environmental lawyer by any means, and I went to law school not to be an environmental lawyer, but yet it sucked me back in like Michael Corleone in Godfather 3. I'm very interested in sort of nationalism versus federalism and the national foreign policy interests, and that's something that's different here, I think, maybe than what the court thought about in AEP or other kinds of preemption cases. Here, the United States is engaged in now 3 international agreements about global warming. And it's very interesting. There's another line of preemption case that comes out of the foreign affairs area where the Supreme Court has been very generous to the federal government in preempting state activity. And in a way, I think that's much stronger than the kind of preemption it perhaps might apply in regular domestic cases. So, for example, I would just there are these cases. One case I would suggest would be Garamendi, which was a case out of here, California, where the state of California, all it did was to say Swiss and German insurance companies that had policies that might have been not paid out to Holocaust victims didn't create any cause of action. All it said is, we want you to provide, if you do business in California, we want you to provide information on the policies that you had out there. Even that was preempted by the Supreme Court in the name of foreign affairs preemption, even though there wasn't even a treaty, even though there was no executive agreement. All that was going on at that time was negotiations between Germany and the life insurance companies and Holocaust survivors that the United States was helping to broker. President Clinton was encouraging the negotiations to reach a settlement, which it ultimately did. That was all that was necessary in the foreign affairs context to produce federal preemption. And here, I think the cause of preemption, if you look at it from the foreign affairs lens, is much stronger when you have, right, this is a very controversial issue, very political issue, as Phil pointed out. We've had fights between the president and the Senate about whether to ratify these agreements and whether they're treaties versus executive agreements. But what's been going on in the global warming context, I think, is much stronger as a foreign relations objective of the United States government than previous cases where the Supreme Court has preempted state action. I think that's a missing dimension from the previous issues that is present here that might cause the court to grant earlier or to put aside percolation because of the national importance. And of course, the national importance of the industry itself is important to national security and defense in a way that other kinds of preemption contexts might not. There was an amicus brief filed in this case, and then I think some of the earlier cases by national security officials saying that the court should intervene because of the crucial importance of energy companies to defense in this kind of environment. So I think it's interesting. If the court were to grant cert, and I think it well might, how would it approach it? And this, I think, is interesting, this question of certain areas, national solutions versus certain areas where you have local solutions. Donald, I'm curious to hear what you think. I have a colleague, Bob Cooter, who's just come out with a book on with Michael Gilbert at the University of Virginia about law and economics approaches to constitutional interpretation. And their argument is the national government should at least have control over the provision of public goods, right? And the question is clean air, is global warming issue a kind of public goods issue, or is this a question of local provision? We don't really need a national solution, so we can allow competitive federalism to operate. I don't know. It seems to me that something like global warming would sort of, by definition, fall into the public goods category. So I think a court would look at it with that perspective. I think the alternate competing view for the court, and one that it would have to think about, is how does that work with its growing commitment to trying to follow or be guided by evidence from the original understanding. And the court, in the midst of this, I wouldn't even call it a revolution. I would feel like a minor bump of descent from the sort of nationalization trend we've had since the New Deal. The court, particularly obviously in the state sovereign immunity area, but also in the Obamacare case, Sebelius, the VAWA case, Morrison, the Lopez case starting in 1995 started this trend of limiting various federal powers like the Commerce Clause, the taxing, not actually taxing is the power that wasn't restricted by Sebelius, but the Spending Clause was even restricted in Sebelius. So the courts engaged in this project, I think, of trying to re-identify the limits on federal power. How would the court think about that in the context of this kind of issue? And so one area where the court, I think, has always struggled to find a footing in the original understanding, I think they might want to do that in this case, is there are various streams of cases that try to stop extraterritorial regulation by the states. The most obvious one, and much to the dislike of first-year law students who are forced to study this, the Dormant Commerce Clause. Right, the Dormant Commerce Clause, which is in the midst of, the court seems to be rethinking the Dormant Commerce Clause these days. You have several justices who've said we're not sure about whether we want to have a Dormant Commerce Clause. This case could be an interesting prompt for it to continue its thoughts about the Dormant Commerce Clause. There's the Dormant Commerce Clause. There's a sort of subspecies about extraterritorial taxation, which actually ties in interestingly with Phil's discussion about, are people really using these lawsuits to try to, place this, which is effectively a functional tax on energy companies? You have this idea of territorial regulation not being able to extend into other states, it's never been clear whether that was a Dormant Commerce Clause issue or just something inherent in the nature of federalism. The courts have always been very unclear about that. When I teach the area, I've always said when you read the court's decisions, something that's really important to the court is, although they never say it up front, seems to be, what do they think the intent of the states really is? Is the intent of the state really to protect, intrastate activity, intrastate public health and safety? Or is the state really trying to engage in extraterritorial regulation? Is it really trying to reach beyond its borders and try to use its state law as a kind of pretext to advance its policy interests beyond the borders of the state? I think that is something you see reflected in some areas of the original Constitution, like the jurisdiction of the federal courts in intrastate disputes, weird clauses like the Port Preferences Clause, things like this, the ban, obviously, on intrastate tariffs and taxes on trade. I think this would be one of the reasons the court might want to grant the cases so that it can address how does the sort of law and economics, I would say, approach to how it's thought about national versus state interact with this effort to restore appreciation for the original Constitution. Lastly, I just want to, I think I have like 5 minutes or less. I hope I have the clock right now.
Yes,
Um,
definitely.
Yeah, so I just have just in a few minutes, I wanted to comment on some things Catherine said, not as criticism. I actually quite agree with many of the things she said about how this issue of displacement and this issue of preemption are different. I think that's quite right. Federal, what the court said in AEP was that if we're going to read the Clean Air Act to vest authority in a single national decision maker about clean air displaces federal common law. That's not quite the same thing as federal preemption. Although I also quite agree with Phil, it's hard to think that what the court said in AEP, we don't want to have judges running around creating federal common law causes of action about transboundary air pollution. It seems weird that you would say, but it's okay to have state judges generating the same causes of action in greater numbers, with greater diversity and differences. And so it's actually, I actually think this would be a good reason for the court to grant cert. And I didn't read Catherine to say anything different, that if you have these different doctrinal approaches and they converge here, does it make sense for the court to reach different outcomes, very different outcomes, using displacement and preemption, or should they actually share more of a common doctrinal heart, as it were? I think that another interesting thing that she pointed out, which I agree with, is the artful pleading is really going on here in very interesting ways. For example, if you look at the most of these cases tried to go to the Supreme Court to appeal cert, and I think they were rejected mostly on the well-pleaded complaint rule. Again, sorry for first years who are suffering PTSD from hearing about things like the Motley Rule, again, which they probably thought they'd never have to hear about again. But right, this is interesting. The court did have the opportunity to hear this issue before and denied cert. Maybe you could read that as a desire for more percolation, more decentralized solution. But I actually think the reason why the court didn't grant cert before is that it could not under the Motley Rule. I thought maybe if it was interested in something like foreign affairs preemption, it might create an exception to Motley, but it did not. But I don't think those earlier grants of cert really give us much hint on what the court's thinking now because of just sort of standard federal courts doctrine. And then I think this is the last point I'll make before I end is, I think in this area, there's a lot of sort of judicial policymaking going on at the Supreme Court level. And so if we're trying to figure out how are they going to think about this, are they going to grant, are they going to decide? I wonder whether they're going to think, because this is what you asked, Donald, what would happen if the court doesn't grant cert? It does seem to me that you're right, that this would allow every city and county to file a similar suit. I don't see why they wouldn't be allowed to. Does the Supreme Court think that that would be a good outcome as a matter of judicial management of this problem, given that they know sooner or later that they're going to have to hear this issue, that it is indeed cert-worthy? That's always a delicate balance. But if the court seems to think these are kind of cookie cutter lawsuits, then it seems to me they would want to take the case earlier rather than later. So thank you very much for bearing with me. I'm really enjoying this discussion. I look forward to comments and questions.
So thank you all. Thank you, Professor Yu, for the final opening remarks. I think that the three opening remarks have all indicated the complexity of both the series of cases under which this kind of litigation is proceeding, but also the variety of issues the Supreme Court has to take into account as it decides whether or not to grant cert. I want to open it up for the panel to discuss amongst themselves for a few minutes before we open it up to audience questions. Did any panelists hear something that they'd like to reply to? All right, Catherine, go ahead, please.
Yeah, and I think I reserved much of my, at least 5 minutes of my opening time, knowing I was sandwiched between two people who'd filed amicus briefs on the side of petitioners. I want to be clear. I think that the preemption issue might be cert worthy. I really disagree, John, with you that the court could use this as a good vehicle to weigh in on foreign affairs preemption. It's not presented in either side's, question presented, or extraterritoriality, although, and the dormant commerce clause, right? It'd be sort of like everyone read what happened in the pork producers case, and it's a very fractured decision. There's lots of discussion about how, you can't have a proper balancing test, et cetera, et cetera. The idea that they would use this case as teed up now by both questions presented on each side to engage in that, I very strongly disagree. However, I agree with you, right? I think law professors should agree when we issue spot on really interesting kind of, as you said, implicitly maybe even left out their issues. So on extraterritoriality, for example, much of my research is on punitive damages, and every single one of the US Supreme Court cases there, even though they decide cases on substantive or procedural due process, there's this language about extraterritorial effect, et cetera. Of course, Justice Gorsuch, in the context of the aforementioned fractured dormant commerce clause, sort of mentions the point, what isn't an extraterritorial effect? So in other words, like a view like that, I think would suggest that we shouldn't have state by state products liability cases. We shouldn't have state by state punitive damages. The breadth of that, or the breadth of taking a kind of law and economics approach about which things should be regulated at which level. There is, for example, just again, to return it to this case in the context in environmental law, Professor Jonathan Adler has pointed out that notwithstanding some of the normative arguments for the use of Clean Water Act and Clean Air Act to deal with extraterritorial effects, those are actually almost never the bases on which those acts have been, enforced. So there could be a divide between our normative view of like what's the optimal level of regulation and how the court's going to see these issues. Second thing that I'd say, maybe I'll just limit myself right here to three. The second thing I'd say is the fact that the Second Circuit's case is, as you described it, out there by itself, and you acknowledge it, I think is a reason. It's not just percolation and, the issues are cleanly presented and the court would just wait. That case and the reasoning, there was a reason I said that I feel like it didn't tackle the question head on. It did read the state causes of action in public nuisance and trespass as federal common law claims. That's not how they were pled, et cetera. It's a pretty aggressive read, and it's a kind of doubling down, I think, on a very expansive view of federal common law that I think this court, for some of the reasons that you mentioned, would be wary of using as kind of one of the, if we're going to say there's two cases presenting a split. Finally, I do think it's worth coming back to, the court is in a position, if you read the questions presented on the petitioners and respondents side, the petitioners frame this as, whether federal law precludes state law claims seeking redress for injuries caused by the effects of interstate and international greenhouse gas emissions. The respondents, putting aside the interlocutory question, frame it as, does the Clean Air Act or federal common law preempt or displace common law causes of action of deceptive consumer marketing and failures to warn, and not the emission of regulated air pollutants? So what might the court think about when they're looking at, how different state courts or federal courts in diversity handling the state court issue? There are a diversity of opinions out there about this state toward action of public nuisance and the metes and bounds of it. And so on the one hand, you have cases where courts have suggested that there is no public nuisance when the underlying claim is something about deceptive marketing, failure to warn, kind of a products liability case. On the other, you have some states that have recognized that. It does seem to me that the court would be in a very uncomfortable position, right? One in which, as you well know, in like punitive damages cases, even when they intervene in a state law remedy, they always talk about how we first start with the legitimate interests of the state, and then we think about what's the federal constitutional argument for intervention. Here, I think that they would have difficulty, given the way that the this one case, and then with the Second Circuit out there, as I said, as not to my mind, a great second pole to maintain this split, that they would be forced into a position where they might be articulating an extremely broad preemptive view, once that's a preemption of the field kind of argument in an area where we have a statute, the Clean Air Act. If we just for a minute pivot and think about how the US Supreme Court has numerous decisions about, the federal, preemption in the context of the Food and Drug Act context, the court, not much to my colleague Richard Epstein's chagrin, has never been persuaded to take a field preemption view, has really focused very much on statutory interpretation. And the final thing I'll say is to get back to like, what's really different? What's different between federal common law displacing or preempting versus federal preemption kinds of questions? What's really different is kind of an interest in the prerogative of legitimate state interests. And in a federalist system, and many of the, I'd say all of the justices of the US Supreme Court have been very attuned to that in a plethora of federal preemption decisions. And it's just not at issue in displacement, federal displacement. It's entirely distinct.
So Donald, if I can jump in just for couple of points that
Please
I heard.
do.
I think that, listening to the two professors is certainly a reason why the Supreme Court should take the case now, because there's a lot of disagreement, a lot of interesting things that are being said. There's 3 points that I want to make about hopefully to put a finer point or clarity on some of the things that we're talking about. So the first point is the question of whether, in the Hawaii case, they said we're going to go with the Fourth Circuit, which they called the majority view, and that the Second Circuit was standing on itself. But that's not true. There were completely different legal questions. What the Fourth Circuit addressed was whether there was sufficient grounds to remove the case to federal court versus remand to state court. And the Second Circuit was looking at whether the claims substantively arose under federal law, even though they were stated as state law claims. That's like if there's a fight breaks out in a bar, is there a battery being committed or a public nuisance committed? You're going to look at the same facts. You're going to look at the same things that happened, but for two completely different legal frameworks and determinations. And so, the Hawaii court's assertion that all the circuits that looked at this issue of removal versus remand is somehow speaks to the issue of substantive questions is just wrong. And so that's something that I think is being overplayed in some ways. The second point is, what are the federal issues that are being put before the Supreme Court? And there are 2. And I just want to and I think both professors would agree with me on this. But I just want to clarify that there are 2 completely separate federal issues. One is this issue of interstate emissions and federalism and kind of the core of our governance. The other is the Clean Air Act preemption question. And so the challenge is, there's arguments for each and against each, and I get that. But I just want to clarify for the audience that there's one set of arguments as this is a federal common law question because it arises under interstate emissions, and therefore no state law or state can govern interstate emissions. And that's one set of arguments. The separate set of arguments is the Clean Air Act preempts any state law claims that are would be in violation of the Clean Air Act. And again, there's arguments on both sides, but I want to make sure that we're clear. These are 2 completely separate legal doctrines, completely separate legal questions for the court to consider. And frankly, as I understand it, why the defense side has 2 separate petitions, because one set of lawyers wanted to focus on one and one set of lawyers wanted to focus on the other. But that's a different question. And then the third thing is this issue of trying to find a state law issue, like whether it's nuisance or marketing practices or failure to warn, what the Supreme Court said in AP versus Connecticut is that any harm or injury caused by interstate emissions is federal in nature. And so if you're saying what happened, in a different part of the chain of causation, so what led to those emissions, once you hit emissions, it becomes federal. So that's why there's a distinction between the state law claims of public nuisance or consumer protection and ultimately the damages for which they're pursuing, or the abatement remedy, whatever you want to call it, that they're trying to pursue, is once you end up going through the prism of interstate emissions, international emissions, it no longer becomes suitable for applying state law. And so again, there's arguments on both sides, but that's those are the three, I think, fundamental questions that are before this court and are issue in this case.
Professor Yu, any additional thoughts?
Yeah, just one or two thoughts, and I know you want to get to questions, and we have less than 20 minutes, so I'll be really, really quick. I quite agree with Catherine. I misstated things when I said, if I implied that they would grant cert to take a foreign affairs preemption question or grant cert on dormant commerce. I don't think they would do that. I think that's fair, that the question presented is really about just preemption of the state tort law claims. What I did mean to say was that I think that if they took the case, those doctrines would then come into play, and that there is a lot of unclarity. For example, when is the court going to apply foreign affairs preemption, and when does it not? In a world, that we've all been thinking about, the world that's becoming globalized, right? Where global warming itself is a example of a global phenomenon to which we contribute and require some kind of supranational regulatory cooperation. But if that's an example of more and more issues having that nature to them, is the court going to allow foreign affairs preemption to grow more and more broadly as issues become more globalized? I also think I quite agree. The Dormant Commerce Clause, it's really puzzling what the court's doing on the Dormant Commerce Clause. As you said, this California pork producer case, I would have thought they would have struck that down in terms of not the doctrine, but what the court had been saying, what justices have been saying about the Dormant Commerce Clause. And I think the Dormant Clause is actually a good example of this other issue I'm talking about, where I think some of the justices feel tension between the doctrinal outcomes of the Dormant Commerce Clause versus their growing attachment to reinvigorating a state's role in regulation. And so I think that these kinds of doctrines, particularly because they do have important roots in the original understanding, but haven't been fully explored by the court, I think they would come into play here. That wouldn't just be, if the court grants cert, it wouldn't just be a straight normal preemption case because of these different features. And then also one last thing about tort law, and I think Catherine and Richard should have their own panel just to themselves for 4 hours, where she and Richard Epstein could talk about all the tort law issues. I was quite persuaded by him, but I'm not a tort scholar, but he really thinks there's just no basis for this at all in normal tort law, right? And he's just like, this is really just this is just extraterritorial regulation masquerading as state tort law. I don't know if you want to talk about that more, Don. I'd be very, we could do that later, flesh that out or explore that more. But to me, in the Dormant Commerce Clause context, when it comes to like trucking and interstate trucking, interstate taxation, the court's doctrine is so flexible that I think what they're really doing is getting at state motivation. And I think if they look closely at state motivation, they're not going to come away thinking this is really about protecting state health and safety. This is really about trying to participate in, might be a nice word of putting it, or interfere with is the bad way of putting it, the national agenda on global warming.
I think it really is becoming a fascinating project for the court to find out where this sorting should be, especially with changing conditions, and taking it back to the roots, right? Because the roots really are about a union and about federalism, not states' rights, right? These things are different. So the state prerogatives are based inside of federal the system, and determining where the states overstep their bounds, I think is going to be a part of a larger project. I'll be curious to see what cases the court wants to address with those. I think we have a dormant commerce clause issue potentially percolating under post-Mallory decisions as well. And so lots of opportunities for the court to try and explore some of this. Why don't we turn to the Q&A? You're still welcome to put some questions in the Q&A box if you'd like. I'll start with one, which is just a clarifying question. An anonymous attendee has asked us, can someone address the issue of the Hawaii Supreme Court ruling and whether it's interlocutory? Honolulu's opposition brief says that that means a high court ruling is in the industry's favor would be premature. I think the question here is how is it that there could be an appeal at this stage, despite the fact that it was only a denial of a motion to dismiss?
So my understanding is that that was the decision that was made in the Hawaii trial court, that they allowed the appeal, the immediate appeal, and then the Hawaii Supreme Court decided to take that. And so then once you end up there, I think, it's in that pipeline, but others may have different perspectives on that.
Anyone else on that question? All right, so let me turn to another question about if the court addresses this, what about the effects by red states to challenge climate compacts, blue state regulations, ESG initiatives, et cetera, under state antitrust, consumer protection, fiduciary duties theories? Do all these also get preempted if the Supreme Court rules in favor of Sunoco? In other words, is this a bigger issue about anything to do with climate, or is this cabined to public nuisance or consumer fraud cases?
I'm happy to say just a bit. I'm curious what Catherine thinks as well. It's not that I would think you would see red states sue to interrupt what blue states are doing. If you assume that red states and blue states have different approaches to global warming, instead, what I would worry about, and this always comes up with these kinds of extraterritorial regulation cases, would you see some kind of reciprocal tit for tat litigation by states, that have energy companies in them against states that are trying to regulate by imposing their own public nuisance litigation against industries in those blue states. So the reason I'm thinking of this is because famously Texas and California have tried to ban travel by each other's officials into their states based, I think, on attitudes about abortion or LGBTQ rights and so on. So what if it worked out this way? And I think this is one thing that the Supreme Court really wouldn't want to see. If the blue states are seen as regulating industries in a way that's harmful to red states, would red states pass public nuisance or use public nuisance laws, say, against Google, or Intel, companies that are really primarily located in blue states, or Facebook, and try to impose similar? What if they said, oh, Facebook doesn't, which is primarily based here in California, just a few miles away from where I am, is Facebook not providing sufficient consumer protection information to everybody who uses it? And should, city like the city of Houston be able to sue Facebook in a similar way? That's what I would be more worried about, would be this sort of opening the door to this kind of encourage these kinds of use of public nuisance to attack, I think, maybe the industries that are primarily located in other states.
I think I read that question along the lines of something that I said earlier, namely, in this context, particularly looking at preemption in the environmental law context. And again, I'm not an environmental law specialist. I've done a lot of work on preemption, particularly in some other adjacent areas, but I will lean heavily here again on Professor Jonathan Adler, who I think has done kind of the most in-depth review of kind of the history of state, not only public nuisance, but also regulatory efforts, and then the Clean Air Act and Clean Water Act in the 70s coming in against that background, and with very broad savings clauses about what they mean to continue to authorize as a matter of state law. I do think that because federal preemption of state environmental law, whether it's common law nuisance claims or statutory law, is clearly the exception and not the rule, that the US Supreme Court would be extremely wary about any kind of a weighing in too broadly, such that it would kind of preempt the field of state tort law claims, whether they're in public nuisance or elsewhere, statutory efforts, et cetera. So again, I mean, part of me just keeps coming back with, like it or not, we live in a federalist system, for example, where we don't have federal products liability law. We've got state by state tort systems, and we've got the US Supreme Court kind of intervening in a very context specific way about figuring out that balance between federal regulation and state tort law. So I don't, an argument, I guess, John, you would be suggesting, well, given the foreign affairs nature, given the dormant commerce clause kind of brooding omnipresence, maybe the court would find this very exceptional and could build a kind of jurisprudence, almost akin to, say, like a major questions exception in administrative law that that wouldn't subject. But I think they'd be very, very wary of wading in, particularly in this context where they don't really have like a clear, robust split in authority on the issue that they would be granting cert.
Right. Look, at the end of the day, the Supreme Court is very good, as Professor Sharkey was just saying. They could go big or they can go small. So if they see the issues that they want to address, if it's simply just a question of if the Congress has acted in a way that has displaced federal common law, does that mean the federal common law no longer exists and something can never be removed to that federal common law? Or not removed. They can never be heard under that federal common law. That one step versus two step thing I was talking about before, that isn't going to have the effect that we just heard about. But that would be hugely significant in helping to drive, this litigation, but then also decide this issue of the interplay between federal and state laws. That I think would be a much more narrow, discrete issue than getting into all these other things. And so I think it just, at the end of the day, comes down to whether what this court sees in this case and whether they want to go big or narrow.
Professor Sharkey, can I ask you a question about the analysis that you presented there about the Clean Air Act and the Clean Water Act and the savings and the residual powers of the states? That, of course, was that interpretation of those acts and as limiting leaves space for the states to continue to control intrastate activity. Correct? Does it make any difference to you that the effect of these, as Phil and John have argued, the effect of these kinds of lawsuits are not to say, we're going to regulate only the activities that happen in Hawaii, or and so maybe we get to the Delaware case where the Delaware decision was, okay, fine, you can continue to prosecute the cases if you can show what happened in Delaware, both and trace the impacts and the cause to Delaware activity. But you can't bring a suit in Delaware for the actions that occurred outside of the state.
Yeah.
Is that a reconciling way to look at sort of Professor Adler's position that you're adopting and others?
Yeah, it could be, except in this context, right? The Wallet case, which again, Professor Adler has written extensively about as well, weighed in on this issue to decide, for example, that if there's interstate pollution, that the downstream state that's affected could bring a state law cause of action and just had to apply the law of the upstream state, right? So they were aware, right? One could say, and Tom Merrill and others have taken the normative position that for extraterritoriality reasons, and potential, taking advantage of internalizing all the gains and exporting all of the costs downstream or what have you, we might want to bring this up a level and have this be at the level of, federal regulation or federal common law. But I don't think that's how the doctrine plays out in this area. The other thing that I'd say, just to come back to what Phil was saying, I guess I don't agree that this case or I'll put it this way, I don't believe that this US Supreme Court would want to take a case to double down, like the Second Circuit did, on the expansiveness of federal common law, right, as kind of judicial policymaking that's necessary in this area. This has been a court that has been extremely cautious about expansions of federal common law. I'll never forget, actually, I had occasion when I was in private practice to stumble upon the government contractor defense. And so then when I had the privilege, when I was a professor at Columbia, to meet Justice Scalia, and in a little round table, someone said, well, he said, ask me about any of my decisions. I said, what about Boyle, which is of course a
Boyle,
federal
yeah.
common law. He said, that's the one case I would disavow, and like got into the
Oh,
whole
really?
idea about federal judicial decision-making, et cetera. So I do, to come back, Donald, to your question, it's a great one. I think sort of as academics, and I myself, for example, have argued about, why we might want to have kind of a federalization of certain areas of the law. I think that's separate and apart from how the US Supreme Court has been managing the doctrinal evolution in both preemption and then specifically in the environmental law preemption context.
Great.
Can
So
I-
let
can
me
I
turn
make
to-
a-
oh, go ahead,
oh.
John.
Just a very small comment is, again, this is why I think foreign affairs and that nature preemption is a different model. But in all these areas, I quite agree, Catherine, that once the court decides to preempt, you're going to have all these knotty questions about how far does the preemption go and how does it really interact with the existing state tort law that you're going to have. And you can see that working on other areas where the court has created a sort of field preemption. I would just point out to immigration, for example, which is obviously getting to the Supreme Court repeatedly now, very politically controversial. But there you see, how does the federal common law of immigration, which does oust apparently all state law, but you still have state tort laws, criminal laws that still affect, right, migrants. No matter what you have, how you answer the national preemption question. I think that's going to be true here, of course, too. That's one of the things. So I can't see the court saying, oh, we're just going to displace all state tort law on the issue of energy companies and the sale of petroleum products. But you still could have national preemption on this issue, still have some space for tort law, even in a context of just complete federal domination of a field.
I think this will have to be our last question. So if each of you could take a turn at it in just maybe 90 seconds or so, I'm going to frame it as a separation of powers question. In other words, whether directly or in the background, how do each of you feel the idea of separation of powers will animate the court's decision whether to take this, or when they eventually do take a case like this, how they will decide it in light of the appropriate role for a legislature in this kind of legislators or administrative agencies in this space of complex scientific issues of climate change versus the courts, and will that have any influence here? And it's my question on that is motivated by Jade Craig's question, which I think is very similar, which is about, oftentimes in these cases, you'll hear the plaintiffs say, we have no other resort. There's a gridlock. There's dysfunction in our political institutions. We need the courts to solve climate change. And so Jade asks, what role does political dysfunction occurring in Congress and partisan gerrymandering and reducing the sense of efficacy that advocates have about addressing the issue in the legislative process, encouraging resort to the courts? So I really think that that's where some of the frustration is. We need the courts because we can't count on the legislatures. But on the other side, the folks who say, well, if you're going to do any kind of regulation in this space, it should be with legislatures. I'll leave that as sort of the tee up for the final question.
Well, I think we all could probably talk for another 15 minutes on that question. One thing I think that is part of the nut of things. And I think, a lot of us get frustrated by the lack of progress in Washington on a lot of issues. That doesn't make them, meet for the judiciary and for judges to step in their place and start making policies on a lot of different issues, whether it's immigration or environment or climate change or what have you. I think one of the interesting questions that was raised a little before was sort of on the intent of the litigations. And Just a couple weeks ago, I saw that there was a letter from some state representatives to the state AG in Minnesota talking about how the lawyers, and I think John mentioned that it's kind of one law firm that's been behind a lot of these cases, but they're getting their funding from foundations who are doing this for the intent of the impact that these would have, the regulatory impact that these would have. And so the lawyers are getting funded to bring these cases. There are centers that are putting, deputy AGs or assistant AGs into offices that they're paying their salaries, all to bring these kinds of cases, all for this larger policy issue. That presents potentially, and this is it'd be a very interesting thing to see this teased out, a different question from what's the motivation of the state or of the town. So when I was on a CBS interviewed me and the mayor of Charleston a year ago about these cases, and he said, I just need money. I don't know that he's out there saying, hey, I need, I'm caring about all these policies. Like, I just need money to build bridges and seawalls. And so I'd rather get it from the oil companies than from my constituents. So I don't know how that plays out in here, but I think but it does set up that there's so many different angles to this, and this sense, and what the proper role of plaintiffs, of the lawyers, of the foundations, of all these people in trying to figure out what to do about climate change. So it all crosses through this litigation.
So, I think that it's interesting to frame that question thinking about the preemption question that we're discussing, because of course, if the touchstone is legislative intent, as I've mentioned before, if you really look carefully at the Clean Air Act, Clean Water Act, there's not only no express preemption clause, there are very broad savings clause, there's a whole situation of kind of a cooperative federalism kind of system that's been set up. So one might think that the kind of argument about judicial policymaking would be on the side of finding like an expansive federal common law and or, preemption as opposed to the other. So that's kind of interesting. Final point I'll say is, back to first years. I can't let Professor Yu be the only one to do a shout out to first years who are taking a break from studying. But, the Boomer case in 1970 is a really great one to think about, a nuisance case just on the eve before the EPA came into being. And there's lots of discussion of the court, like we can't handle all the pollution problems. This is a society ill, but we've got a case before us of some landowners who have a state tort claim, and we're going to resolve that. So that's kind of, that framework is another one to put forward about, it's not sort of courts versus, policymakers. It's an idea of what is the proper role for the evolution of common law torts within our complicated federal system.
I would just add, Catherine mentioned just briefly, or a lot earlier in the discussion, the major questions doctrine. And there is where separation of powers intersects with federalism. And the court, I think, is using this to say we're not going to allow the expansion of the administrative state beyond what's proper, but also trying to, I think what's really going on is force accountability to Congress, force Congress to make the major important decisions. You could say that's what's behind AEP is, the judiciary is not going to sort of siphon off power in this area from Congress. And maybe that's how this would tie in with the preemption federalism issues is maybe in certain areas, right, they're going to protect states with the major question doctrine, but certain areas are going to protect the federal government with it. This is a theory, I think we didn't mention them, or there's a very aggressive federal preemption theory advanced by Brad Clark at GW and AJ Belia at Notre Dame, which would say, what's really going on here is when the courts preempt in these federalism areas, what they're really trying to do is preserve the sphere of action for the federal government and particularly Congress. And their analysis would say they should preempt here so that Congress can shape global warming policy without having to worry about state laws already disrupting the field on which it can act.
Well, thank you very much. 90 minutes is never enough time to exhaust all these issues, but it's certainly enough time to get better informed. And I think all of our panelists have done a great job getting us to that point. I thank each of our panelists for participating in this program. I thank all of you for participating as attendees on this program, either live or in the on-demand version. I do encourage you to go to masonlec.org. That's masonlec.org to look for past programs from the Law and Economics Center. We provide all of our programs as a public service. If you'd like to donate, you can also do that at masonlec.org. We would appreciate your support. And especially I want to remind all of you something I forgot to say at the very beginning of this. This is the 50th anniversary of the Law and Economics Center. And so we've been
Congratulations.
We've been doing this for a long time, but only because of the support of all of you and only because of the participation of great panelists like we had today and great participants in our audiences. Thank you again. I hope you all have a wonderful weekend and a great afternoon. Take care.